Hey folks, Troy Dooley, the Beachside CEO, and I'm hoping you're having a fantastic Valentine's Day. This is the first Valentine's of the third decade of the 21st century. And it's amazing we're this far into it. And what a beautiful, I know today it's beautiful, sunshiny. I'm looking forward to tonight and just relaxing and celebrating with my woman and my wife. So it's going to be fun. But this is like I think the second or third installment that we have done on sharing services, Elepreneurs, Elevacity. Any of you guys, you know that we've got a ton of links, a ton of stuff we've put up, asking questions, looking at the facts, trying to figure out where is everything, because it's somewhat convoluted. A lot of times you see people say we want the truth. And I think that's the goal anytime you launch into some type of a story is, hey, where's this go? In this one here, it's really tough. I mean, you've got facts that have been presented in the courts, facts that have been presented to the Securities and Exchange Commission from both sides. And when you read one side, you think, whoa, man, this is tough. Then you go over here and you read the other side, and it's like, this is like just totally opposite. What the heck? And it's tough. And I've told people, I don't know what the truth is. I believe that there's been some mistakes made by everyone that's involved. I'm a firm believer that the majority of the humans that God has created on this earth are good and great people, but there's also those that obviously will just surprise you at times. They look good, they act good, they've been nice, they've been business people, they've been church leaders, they've been your next door neighbor, and then you find out that they got a crazy and shady past, and you just never know. So when we looked at this, we've tried to go through the whole thing, try to stay as non-judgmental on both sides as we can. Obviously, my opinions come out sometimes. I did a video earlier this week just getting pissed off at people because they use all the information they can get to cross-recruit. They can't just go out and build a business on their own. So right after I did mine, Todd Falcone did one. I mean, this is just a pet peeve, but not to digress. This came up last week. Last week was kind of was one of those old school Barnum and Bailey circus, the clowns that used to come out in the middle, and it's kind of how I felt that this was. First, a memo. It looks like this memo was from the Office of the Chief Executive Officer, Elepreneurs US LLC. I'll show you that right there. I'm assuming, since it says from the office of, that it's Kip Allison, who is the Chief Executive Officer. I believe that Mr. Keith Halls is the president. Now, they're both directors on the board of the PubCo, which is Sharing Services Global Corporation. And the reason I think this was Allison is because at the end, in the back, he goes into first person from just kind of trying to be generically factual. Right after this, Robert Oblon puts out a public statement, public post, I guess I better say it that way, that he was going live to tell the truth, because we're going to go through just a little bit of this, but if this stuff isn't true, this is purely, I mean, defamation of character like crazy in my opinion. I'm not an attorney, excuse me, I'm gonna get a drink. But I mean, this is personal attacks is what it is. It's to truly from this side make it look as if Robert Oblong is a Jeffrey Dahmer type person. The whole saga, if you will, reminds me of, I don't remember how many of you guys remember the original Dallas show. And I bring that up because this company's out of Dallas, and that was brother against brother, friend against friend, long-term, attorney against my client. And that's how this is all, it's just a mess. And then right after Robert put his thing public, the company came out and tried to file a TRO against Robert talking, claiming he was going to give discredit the company, disparage the company. And inside of that was a personal affidavit from Mr. Keith Halls. And in number 5, it stated that I was in concert with Robert Oblong to put out incorrect information from the company, that all the information I've been putting out has come from Robert Oblong, and that they had a transcript of my video. Now, if you guys have watched the videos, then you know there's a link to the actual article where the video is embedded, where we list the SEC filings and we list the links to those. We put the questions up. As long as, and there's a website, Happy Coffee Truth, or the Truth About Happy Coffee, that has all the court documents that are on it. So we put it all together because we're looking for facts, not for subjective comment, if you will. And I think that Keith is older than I am, and sometimes in the heat of stuff and you're working, you just get absent-minded on things. I've got like 5, 6 kids at home and 9 kids total, and I do that. So I can understand how Keith could do that. You're trying to run a pubco. And he seems to have forgotten that we have text messages between the two of us. We have emails between the two of us, where I have asked him the same exact questions that I asked Robert Oblong. Matter of fact, I sent them both unblinded, just email, hey, I'd like to have these answers. Robert Oblong never responded to that email. Keith's assistant wrote me back and said, look, the board of directors would be happy to talk to you after the court case is over. We're a publicly traded company. We cannot talk about any of this. And whereas that's not true, I mean, if that was the truth, you'd never see anything on CNBC, MSNBC, Fox Business, or any of that. There's things you can talk to. If it's public filing, if it's in the file, you can talk about it. You can also have your legal team make the statement for you, and that way it's not held against you. But in that case, it seems that Keith forgot, because he said he had personal knowledge. And that's not accurate. I'm not in concert with Robert Oblong. I don't know that Robert Oblong is 100% accurate in this. I don't know that these people are, Keith, Allison, and Kip and the board of directors is 100% correct in this. We're following the facts, and the facts don't point yet to one side or the other. And this memo that Keith put out, not Keith, excuse me, Kip put out, or seems to have put out, I'm not even sure his legal team had seen it. I know that the board of directors, which Kip sets on, did not do the due diligence in this, or they would not have allowed it. At least I would hope they wouldn't have allowed it to be put out. And here, I want just a couple of things. The first is that this is the heading, why Robert Oblong left the company. Robert Oblong was removed, so that means he didn't leave, he was removed from the board of directors and stripped of his position of authority in the company as a result of gross financial misconduct. That's not of purported gross, of maybe, this is a result of gross financial conduct. He voluntarily resigned to avoid punitive legal actions. Now, you were either removed and stripped, or you voluntarily left. Now, if there's gross financial misconduct as purported in here, I looked for it in the filings, because in the filings, going back as far as we could go, we never found once where the company had filed any amended returns, any type of notice to the SEC that, hey, our audited financial statements may be inaccurate. I saw nowhere where they mentioned that the third-party law CPA firm that usually does your audits and signs off on the audited returns had been notified that there was discrepancy due to gross financial misconduct. So it's like, okay, I'm a little perplexed on that. I'm also perplexed because if there's gross financial misconduct, every one of the filings that we could find said that all of the legal actions and all of the stuff that they had found by former insiders had no material disposition, basically, on the activities of the company. It wasn't going to matter one way or the other, no matter what the findings were. But yet here it says it's gross financial misconduct. So that was a little concerning to me. And then another paragraph. Let me show you this one. This is on page 2. We're going to put these up in the article here. It says our company startup losses and mismanagement of Oblong. Again, it brings this up. Now, this one here is a little tricky because they weave in stuff that has no material well-being, period. It doesn't even matter. And that they put it in here. And here's what it says. From February 2012 until December 2016, Robert, I'm assuming Robert Oblong, borrowed money from people under the guise that he was starting new companies that would pay back the lender. Now, anytime an entrepreneur borrows money, the goal isn't just to pay back the lender, but it's also to make a profit so that they can get paid. Sometimes that happens, sometimes it doesn't. That's a risk that's taken. But then it switches and says, under the current management, that the company began evaluating these ventures and underlying documents for purposes of evaluating the financial exposure. Then it switches again. And it says, under these ventures, there was over 1.2 million of unpaid obligations, with approximately 730,000 owed to Jordan Brock's family and friends. We go from Oblong prior to the launch of this company to the current management trying to figure out how exposed are they, and understand during part of this, Kip Allison was Robert Oblong's divorce attorney. He's actually listed at Wiki Corporate as being on at least one of the documents tying these guys together. But then the next paragraph says, none of these debts are subject to payback by the company because the money was not used by Sharing Services or any company that became part of Sharing Services. So why even put it in there? That has nothing to do with mismanagement. That's other ventures that may be successful for all we know. It doesn't say one way or the other. Now, it goes on at the bottom. It says Oblong's poor management and use of company funds. Now, this is important here because this is where we go back to the original in the beginning. And I know, man, forgive me, guys, I don't do this day to day. I'm not on Fox News or NBC, so it may be a little amateur. Hope you don't mind. But going back here, it says Oblong was removed from the board of directors and stripped of his position of authority for gross financial misconduct. So down here, it says, at one time, Oblong was an officer and director of Sharing Services, December 17 through February 19. Notice up here, they were talking about February 2012 through December 2016. There's a year's, nothing happened. Nobody knows here. As a board member and an officer, Oblong owed a fiduciary responsibility, a fiduciary duty to the company, to its shareholders, and to the public. He was obligated to operate the company lawfully and in accordance with all regulatory requirements for a pubco, which includes, if there's been gross financial misconduct and that's been uncovered, then that needs to be reported to the Securities and Exchange Commission. There's a opportunity here where our returns, the numbers that we filed in our 10Qs, all those paperwork, all that could be wrong if what they say is true. If what's purported here, there was gross financial misconduct that Robert Oblong used corporate money for personal. There literally are obligations to the board of directors, to the chief financial officer, to the CEO, and to the CPA firm that should have uncovered this. This opens up a whole potential for a whole new bag of worms here, and it's interesting because it says he did not do any of this. He didn't. A fiduciary duty is the highest duty recognized by law. It requires the officer, a person entrusted with the property of others, to always exercise their business judgment for the benefit of the company and never engage in self-dealings for their own benefit or profit. But yet, we don't see anywhere. We do see some court filings on this. But if the standard of excellence is that you don't owe anybody from your past money, that you've not mismanaged anybody else's property, that you're doing everything 100% correct. And I believe it is. I believe the Securities Act of 33 and 34, along with several other rules that are in place with the Securities and Exchange Commission, prove this out. Then I would challenge the current board of directors and the current executive leadership to do due diligence before just turning over the reins, if you will. Because Kip Hughes Allison, who was personal attorney to Robert Oblon, is the trustee of stock, the Class B shares of stock that really control certain parts of the business, certain things that can and can't be done. Is also an officer of the company. Then you should look at his background. Some of the public records that we've uncovered include gross financial misconduct, includes one such document charges Kip Allison and Allison and Johnson LLP for falling below the standards of professional care, fell below the standards of good and workmanlike legal services, constituted negligence, breached express warranties, constituted professional negligence, violated the Texas Deceptive Trades Practice Act, breached fiduciary duties, and breached defendant's contract with the client. And Miss Karen Ann Irwin is requesting $1 million. This was filed in 2004. She alleged in this filing, similar to what this memo alleges of Robert Oblon, that Kip Allison lost several trash bags of financial documents that had been shared by her husband that she was suing, that Kip Allison lost the shredder box that she had sent him, that Kip Allison lost all of her husband's pornographic tapes, receipt of the tapes, and the female undergarments that her husband wore during their marriage. She had turned these all over to Kip Allison, and he had lost them. I thought, well, that's kind of awkward. And then I found another one here where Kip Allison was in a final judgment from Murray Holland. Here we go, this one here. This was filed April of 2016. And the judge awarded $67,000 on a breach. So we looked a little deeper to try to find that out. And then we found this was just filed. This is against Legacy State Bank because Kip Allison hasn't paid a court judgment of $67,000 to Murray Holland. It says that this is under the court, that Kip owes 67 plus 41. Looks like he paid some of it and then stopped paying. This is all maybe small stuff. We're going to put up 6 different cases that show this. We've got a case here we're going to show where the retainer of $7,000 came up missing. We're going to show where Kip Hughes Allison was in the middle of some kind of political corruption case in the family courts in the state of Florida. This was reported by a local television news reporter who actually got an award for his investigative reporting. We're going to show sanctions by the Texas bar. These are breaches in fiduciary responsibility to clients. It's also gross financial misconduct if these are all true. And since the judgments and the sanctions are there, some of these are true. Some of them were found against Mr. Kip Allison. And then I found something very interesting. We started putting the dates together. Kip H. Allison, counsel, brings this motion to withdraw as counsel Kip is the counsel for the plaintiff, which is Mr. Ryan. This was filed 1/8/2019. Kip Allison had started working with sharing services in the fall of 2018. Now, again, I challenge the board of directors to do their due diligence. We're going to put these up in the post. It says in here, good cause exists for withdrawal of Kip H. Allison as counsel to plaintiff. This case is set for a 4-day jury trial beginning January 14th, 2019. Allison suffers a disability that renders him unable to conduct the trial or continue legal representation of his client in this manner. Plaintiff sued the defendant for breach of contract. The plaintiff may decide to sue their attorney before this is over. I don't know. It says, beginning July 2018, counsel for plaintiff, Kip H. Allison, suffered a series of medical infections in his inner ear, leaving him with such a diminished hearing that he could no longer competently represent clients in legal proceedings. I challenge you to go back and look at when Kip Allison first started working for sharing services. The medical conditions were treated by specialists, including surgical procedures attempting to stay and recover the damage done to the hearing. None of the procedures were successful. After exhausting medical opportunities through October of 18, Allison attempted to continue his practice, but learned he was no longer capable of competent representation with his diminished hearing. I am in no way making light of somebody's disabilities, if they truly are disabilities. On or around November 1st, 2018, Allison made the decision to close his practice and begin the process of finding new counsel for current cases and withdrawing from cases still active. On November 31st, 2018, Allison closed his legal offices but continued to work with his clients to transfer his cases. I again challenge you to look at when Kip Allison came on the scenes of Sharing Services Global Corporation, Elepreneurs, Entrepreneurs. What has he filed himself in court cases for that corporation and those companies? What actions as a director, what actions as an officer has he taken for the corporation with such a medical disability? Was that medical disability disclosed to the board of directors prior to it going public right now? Those are the questions that we must ask. Allison contacted several competent attorneys to review this pending matter, but because of the holidays and existing schedules, were unable to secure new counsel. During this same period, Allison attended several hearings trying to complete cases for clients, became acutely aware his hearing deficiency impaired its abilities in court. Think about this. As an expert witness, I've been in courts a lot. In my early days, as a bail bondsman and a bounty hunter, I was in court all the time. Courtrooms are very quiet for the most part. It's not like on TV. If an individual cannot hear in a courtroom where there's a mic and silence, how can they conduct the business of a publicly traded company in a boardroom, in the matter of terminations, in the matter of acquisitions, in the matter of just the day-to-day operations? And what would make it any different now? If you can conduct your business now, what was different then? Has healing taken place? I believe healing can happen. I know that when I was introduced to Kip Allison in June, July of last year, was in the lobby of a very busy and loud hotel with very bad acoustics. Garrett McGrath had yelled, "Kip, come here, I'd like to introduce you to Troy Dooley." And he went on to say, "Kip is the new COO over at Elepreneurs and Elevacity." And we shook hands. He didn't seem to have any problem hearing Garrett call his name after he had passed us. So it's very interesting that now, about the time that he came on board, at sharing services and Elepreneurs, Elevacity, that his hearing became bad. I would challenge the board, if you're going to hold someone to a level of excellence, as is stated in this memo, that Robert Oblon was relieved of his duties for gross financial misconduct. If the company has not filed amended returns, if the company has not asked its chief financial officer, how come you didn't disclose this? How come you didn't find this? If the CPA firm that has audited the financial statements, if they have been audited, I assume they have, reputably so. If you haven't notified them that there could be discrepancies and they need to go back through, then I would question who is actually innocent in all this. Because it seems to me when you file with the Securities and Exchange Commission and you file public documents that you are going to be taking care of the fiduciary responsibilities of the asset owned by a boatload of shareholders in a pubco, pink sheet to NASDAQ to New York Stock Exchange. That is the board of directors as the current executives in the company. You'd want to make sure you were doing this right so you didn't get implicated in all of this yourselves. At the end of, or at the beginning of this week, as we close this down, a new TRO was upheld that basically stayed the voting of the Class B shares. To date, we're watching. We haven't heard where that's going to be. I don't see any changes at sharing services. But if those in the Robert Oblon camp, as we've seen on the internet, as we've seen in several lives, would have us believe, that hearing could cause a shift, a disruption in sharing services. Means that the Class B shares, which control kind of the board, that means that the addition to having Keith Halls and Kip Allison on the board of directors would basically be null and void. A new vote would have to take place. If that's the way it works, it's going to be hard to understand what happens. Will the lawsuits go forward? Will they not? It could be appealed, and if it's appealed and the judge in the appellate court says, well, we're just going to leave this as it is for now, we're going to dig a little deeper, it would leave everything status quo. And if it stays status quo, that means the board of directors would be Keith, Kip, and JT. Which means that Keith and JT have the fiduciary responsibility to hold Kip Allison to the same high level of excellence when it comes to gross financial misconduct, breach of fiduciary responsibilities, lack of disclosure, because I haven't seen any of this disclosed in any of the public filings to notify the SEC of any pending or past judgments, sanctions, or anything against Kip Allison. And I would think that a company with the reputation that Sharing Services Global Corporation has would not want it tarnished or tainted with such actions. I remember a few years ago, I sat on the board of directors with Keith Halls and Garrett McGrath. This was about 2014, actually, because in 2013, I was sanctioned by the Securities and Exchange Commission for an infraction for not disclosing part of my contract with a company called Rex Venture Group, which was the parent company of Zeke Rewards. I was asked to resign from that board of directors by Garrett so that the board wouldn't have to vote to remove me. I thought it was honorable. This is actually the kind of guy that Garrett is. And as I thought through it and I thought of the mission of the A&MP, I thought he has a valid point. It's not about me, it's about the mission of the organization. Why would I put friends, maybe foes, through voting me off of a board because of an infraction that cost me a little over $3,000 with the Securities and Exchange Commission. So I resigned, supported the ANP ever since, supported Garrett, I support the board members. But Keith, with that level of excellence, I would challenge you now to dig deep. You're an excellent professional in the Association of Network Marketing Professionals. You've had an excellent career inside of direct sales. And the people in the field, from Garrett McGrath down, trust your judgment. But if this is true, if the documents filed here that show the sanctions, the gross misconduct, and the lack of fiduciary responsibility of Mr. Kip Hughes Allison, then until all this can be figured out, maybe he's not the one to be the CEO of a company that's charging its former directors and executive of gross financial misconduct, of breach and fiduciary responsibilities. Your reps have fought long and hard for you. They believe in this company. They believe in the mission of this company. And the board of directors of Sharing Services Global Corporation owe them the ability to grow this company to the level that they've been promised. And that this company will be above reproach, that this company will not fall into the same trap that other direct sales companies fall into. And that's where I'd leave it. A lot more questions, no answers. Still not sure which side is going to win in the lawsuits. All I know is that the field force deserves to be able to hold their head proudly and say, we love our leadership, we trust our leadership, and no, our leadership have never been sanctioned for a breach of fiduciary responsibility, for fraud, for lying, for political corruption, for anything like that. Folks, live life like it's an epic adventure. Stay dangerous, stay strong, and if you're in network marketing, then act like it.